Do you keep paying bills during probate? If you've just been named a personal representative of an estate, one of the very first questions you're going to face is, which bills do I keep paying and which ones can wait? It sounds simple, but get it wrong and you could be exposed to personal liability. Get it right and you protect the estate, preserve its value, and fulfill your legal duty to everyone who depends on you. Stick with me. I'm going to walk you through exactly what you need to know. I'm Terry Peterson with St. Louis Family Resources. I talk with people every day just like you that are managing an estate, probate, or exploring senior transitions. I open my Rolodex of service providers, contractors, and professionals I've amassed over the past 20 years to help our clients meet their obligations in managing the estate. I invite you to reach out to me via text, phone, or email. Now, back to this video. Your fiduciary duty as a personal representative. The moment you're appointed a personal representative by the court, you take on a fiduciary duty to the estate, meaning you are legally obligated to act in the best interest of the beneficiaries and creditors at all times. Every financial decision you make must be made with that obligation in mind. This isn't just a moral responsibility, it's a legal one, and Missouri courts take it seriously. Under Missouri law, the personal representative has explicit authority and responsibility to pay taxes, assessments, and other expenses necessary for the administration of the estate, and to insure the estate assets against damage and loss. Failing to act can be just as costly as acting improperly. Important, power of attorney ends at death. Before we get into bills, there's something many families don't realize until it's too late. If someone was managing the decedent's finances under a power of attorney, even a durable power of attorney, that authority ends the moment the person passes away. It does not transfer into probate. That means any family member who had been paying bills or managing accounts under a power of attorney no longer has the legal authority to do so after death. Acting on a terminated POA can create legal complications. The proper authority to manage the estate comes from the court through letters of testamentary or letters of administration issued to the personal representative. Bills you should keep paying right away. Even before the probate is formally opened, certain bills tied to real estate must be kept current. These are property-related obligations that, if unpaid, can result in direct financial harm to the estate, and they can't wait for the court process to play out. These include mortgage payments. Missing payments can trigger late fees, damage credit, and in a prolonged situation, lead to foreclosure proceedings against the estate property. Homeowners insurance. Coverage must remain active. If a property is vacant, notify the insurer immediately. Standard homeowners policies may not cover vacant properties, and a rider or separate policy may be required. Property taxes. Delinquent property taxes can result in penalties, interest, and ultimately a tax lien or tax sale. Homeowners association dues and assessments. Unpaid HOA fees can result in liens against the property, fines, and in some cases, a foreclosure by the association. Utilities necessary to maintain the property. Electric, gas, water, and similar services that keep the property safe, habitable, and free from damage, such as frozen pipes or mold. The guiding principle here is straightforward. If not paying a bill could cause the property to deteriorate in value or become subject to a lien or foreclosure, it needs to be paid. Bills that should wait. Here's where many well-intentioned family members make costly mistakes. Beyond the property maintenance bills listed above, most other bills, credit cards, medical bills, personal loans, subscription services, should not be paid immediately. Why? Because under Missouri law, debts must be paid in a specific priority order, and creditors are given a 6-month window to file claims against the estate after the notice is published. If you start paying general creditors before that period closes and before you know the full scope of the estate's obligations, you may be inadvertently paying lower priority debts while higher priority ones go unsatisfied, and you could be held personally responsible for the difference. Per Missouri law, a personal representative who distributes or pays out estate assets prematurely can be held personally liable for the value of those assets. This is not a risk worth taking. The priority order for paying debts. Once the creditor claim period has closed and all valid claims are known, Missouri law, under Revisor Statute 473.397, establishes a strict priority order for how debts are paid from the estate. Higher classes must be paid in full before lower classes receive anything. Number one, costs of the estate administration, court fees, attorney's fees, and personal representative expenses. Number two, reasonable funeral and burial expenses. 3, debts with preference under federal law, such as certain federal tax obligations. 4, state and local taxes and assessments. 5, debts with preference under Missouri state law. 6, wages owed to employees of the decedent. 7, medical and hospital expenses from the decedent's last illness. 8, all other claims, including credit cards, personal loans, and general creditors. This order matters enormously. If the estate doesn't have enough funds to pay all debts, lower priority creditors may receive nothing, and that is legally permissible. But paying a Class 8 creditor before a Class 2 funeral bill is not. Opening an estate bank account. Once you have your letters testamentary or letters of administration in hand, one of the first practical steps should be opening a dedicated estate bank account. This account is used exclusively for estate transactions, depositing estate income, paying property bills, and eventually settling debts and distributing assets. Why does this matter? Because commingling estate funds with your personal funds is a serious breach of your fiduciary duty and can expose you to personal liability. Every dollar in and every dollar out needs to be clearly documented and traceable. Your probate attorney can advise you on the type of account to open and what documentation the bank will require, which typically includes your letters, a tax identification number for the estate. 2 rules you must never break. 2 bright lines that no personal representative should ever cross. Do not pay estate bills from your personal funds without a clear plan for reimbursement. While out-of-pocket expenses are reimbursable from the estate, paying bills personally and then seeking reimbursement can create accounting complications, raise questions, and in some situations create tax issues. Do not use estate funds for personal purposes. This is called self-dealing, and it's a breach of fiduciary duty that can result in personal liability, removal as a personal representative, and extreme cases, criminal exposure. All estate expenses should flow through the estate bank account, and all transactions should be documented with receipts and a clear notation of the purpose. Keep meticulous records. As personal representative, you will be required to file a formal accounting with the court, a detailed record of all income received, all expenses paid, and all distributions made during the administration of the estate. This isn't optional, and sloppy record keeping can lead to court challenges, delays, and personal liability. From day one, keep receipts for every payment. Record the date, the payee, the amount, and the purpose. If you're paying a mortgage note, a loan number, and the property address. If you're paying a utility bill, note the service address. Your probate attorney will walk you through the specific reporting requirements, but the habit of documenting everything from the start will save you significant stress later. What we can help with. As your probate real estate broker, I can assist you in identifying what financial obligations are attached to the estate-owned real estate. That includes researching what mortgages or liens are recorded against the property, identifying any HOA associations and their fee structures, and providing a current market analysis so you understand the property's value relative to its obligations. If you haven't yet engaged a probate attorney, we can also connect you with attorneys our clients have worked with and trusted. Please don't hesitate to reach out. We're here to help you navigate all of this from day one. Being named a personal representative is a significant responsibility, but you don't have to figure it out all on your own. Understand which bills to pay, in what order, and from what account is foundational to doing this job well and protecting yourself in the process. I'm Terry Peterson. Check out our YouTube channel for more videos covering every aspect of the probate process in detail. And visit our website, stlouisfamilyresources.com, for a full library of resources. Feel free to reach out with any questions. I'm here to help. Thanks so much for watching. We'll see you in the next video.